Friends, I really don't want to sound like I'm beating a dead horse, and I don't want to come across as like some kind of chicken little running around saying the end of representative self-government is at hand. The end of representative self-government is at hand. But what happened this week in the House Civil Justice Subcommittee in regard to House Resolution 23 is vitally important. And it does portend the end of representative self-government. Is that hyperbole? Sorry, no. In fact, I choose those words on purpose because they were used by Justice Clarence Thomas a couple of weeks ago in a case eerily similar to this. If you didn't like what the Pennsylvania Supreme Court did when it changed the laws for the election system in the state of Pennsylvania, and the Supreme Court refused to hear the lawsuit by Texas that our Attorney General filed an amicus brief in support of, then you need to understand how serious this is. Now, let me explain what happened, or what the resolution is, for those that have not watched previous videos. The resolution calls for the House to set up a committee of members, urges the Senate to set up its own committee, and for the two committees, House and Senate, to investigate the decision by Chancellor Lyle here in Davidson County regarding the absentee ballot laws that changed the way absentee ballots were allowed to be collected or issued for the August election. Now, it doesn't call for her removal, but the committee can, after it investigates, make a recommendation she be removed from office. Now, what am I talking about? That this is like a case in front of the U.S. Supreme Court involving the elections in Pennsylvania. Well, a couple of weeks ago, Justices Alito, Gorsuch, and Clarence Thomas filed dissenting opinions to the Supreme Court's refusal to hear that case. Now, one of the arguments here that you're going to hear is, well, maybe the chancellor made a mistake, but, this was a confluence of terrible situations and a pandemic, and people were afraid they were going to get sick and they were going to die. And so, maybe she made a mistake, but let's move on. This isn't going to happen again. Well, that was the exact same argument that was made for why the U.S. Supreme Court should not hear the Texas lawsuit. And let me explain what Justice Alito said in response to this argument, because it applies here. He said this. This argument, quote, does not acknowledge the breadth of the Pennsylvania Supreme Court's decision. That decision claims that a state constitutional provision guaranteeing free and equal access elections, or free and equal elections, gives Pennsylvania courts the authority to override even very specific and unambiguous rules adopted by the legislature for the conduct of federal elections. Now, in August, we were having state elections, but we were also simultaneously having federal primaries. So the situation's the same. And here's what he said to this idea that, well, we should let this matter with Chancellor Lyle go. We should let this matter with Pennsylvania go because it may never happen again. Alito continued, that issue is surely capable of repetition in future elections. In other words, there's going to be somebody come in the next time and say, well, the absentee ballot law doesn't go far enough or some other problem with it, and it violates my right to vote. So the issue will come back up. You just count on it. And then he said, indeed, it would be surprising if parties who are unhappy with the legislature's rules do not invoke this decision and ask state courts to substitute rules that they find more advantageous. Now, again, here's going to be the argument against me, and I'm going to answer it. Well, but the Tennessee Supreme Court reversed Chancellor Lyle, and they said she didn't have the authority to say that fear of COVID is a new exception to the ballot law. Now, one thing you need to appreciate is that the court was trying to say, well, is this law valid on its face, the absentee ballot law? I mean, it just can never be constitutional. And they said no, but it might be unconstitutional in certain circumstances. And the court looked at it and said, there's nothing ambiguous in this statute. There are exceptions in this statute. And for us to interpret unambiguous words to somehow include fear of COVID, well, that's a policy decision, and we can't apply that. That's good. But here's the problem. when you're taking an as applied challenge, saying, as to me, this law is unconstitutional, then how in the world could the chancellor have thought she could apply that ruling beyond the plaintiffs to everybody in the state of Tennessee? Now, while the Tennessee Supreme Court certainly said that was a policy decision you shouldn't make, the court said nothing about the fact that in an as-applied type situation, you can extend that exception to everybody in the state of Tennessee. Nobody said that. Apparently, nobody in the Attorney General's office maybe even argued that. There's the key problem. Judges who think that they can go beyond the jurisdiction of the court, beyond giving relief to the people who filed the lawsuit, to apply it to everybody in the state of Tennessee. You don't have a right to your own absentee ballot exception rules and then say those should apply to everybody in the state. You just don't. That's making law. That's the legislature's function. And of course, that will be used in the next case. I would use it. I'd say, look, hey, the Supreme Court apparently thinks that a judge can find an exception to the law or make a new provision and apply it to everybody in the state. Because you said nothing about it. The Attorney General didn't argue against it, and that's what Chancellor Lyle did. So I assume must be okay, right? I'll use that precedent. Now, let me tell you another reason why this is such a problem. What if somebody else had filed this exact same lawsuit with a different lawyer in Davidson County? And so now there's one in front of Chancellor Lyle and one in front of another chancellor. Well, Chancellor Lyle's decision does not bind the other circuit court judge down there, and he could look at it like I did and say, wait a minute, I can't, I'm not going to do this, and I sure can't extend it beyond the particular plaintiffs. We'd have two conflicting rulings out of the same county by different judges. That's what happens when judges think they can make law. See, you and I were not represented down in Chancellor Lyle's courtroom, and yet she thought a decision that she made to help out particular people because of some particular problem associated with them could be extended to everybody in the state. That needs to stop, my friends. And this goes to what Clarence Thomas said in his dissenting opinion. And it goes to this whole issue of representative self-government. Changing the rules in the middle of the game is bad enough. That's what Chancellor Lyle purported to do. And then he said, such rule changes by officials who may lack authority to do so is even worse. See, when you don't even have the authority to do it, and yet you do it, and then you apply it to everybody in the state, that's terrible. And here's why he says this. Next sentence. When those changes alter election results, and who's to say they won't alter the election results in the next election? They can severely damage the electoral system on which our self-governance so heavily depends. See, this is an issue of whether representative state government still exists. And our legislators need to understand that they need to chill this idea by a judge, that they can rewrite the law, maybe even for a particular need of a particular person, and then extend that rewriting of the law to everybody in the state of Tennessee. Representative self-government is dead, as Clarence Thomas said, when that begins to happen and our legislators who are supposed to represent us say, hey, my constituents were not represented in your courtroom and you went too far. We need to put an end to this legislating by judges and send a chill throughout the whole state legislative branch that if you're going to extend your ruling to people who are not before you, you may be subject to removal too because you don't have the authority to make law for everybody in the state of Tennessee. If we allow that to continue to happen and those who are supposed to represent us allow us to that to continue to happen, then we don't have representative self-government except in name only. I hope you appreciate what's at stake.